The West Virginia Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of West Virginia. What is a rental agreement? A rental agreement, or a lease, is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, there are no other mandatory lease disclosures in West Virginia. Security deposits. In the state of West Virginia, the security deposit is completely up to the landlord. The landlord can use the deposit to pay unpaid rent or repair any property damages caused by the tenant after conducting an inspection for damages on the premise. The deposit should be returned by the landlord within 60 days of the termination of the tenancy or within 45 days of the occupation of the premise by a subsequent tenant, whichever time period is shorter. If there is any damage to the premises, and they exceed the amount of the security deposit and require the services of a third-party contractor, the landlord shall have an additional 15-day period to provide an itemization of the damages and the cost of repair. The landlord who intentionally fails to return the security deposit, along with the itemized statement of damages, should return to the tenant the amount of any unreturned security deposit along with damages for annoyance or inconvenience resulting from the landlord's nonconformance equal to 1.5 times the amount wrongfully withheld. Landlord access. The West Virginia Code does not set the requirement for the landlord to provide the tenant with a notice before entering the premises. However, a 24-hour notice is recommended. Termination of agreement. To terminate a year-to-year tenancy, a notice of termination should be sent at least 3 months before the expected date by either party. To terminate a month-to-month tenancy, at least 1 month notice should be sent before the expected date by either party. To terminate a week-to-week tenancy, at least 1 week notice should be sent before the expected date by either party. Notices for non-payment and non-compliance. If the tenant fails to pay rent, West Virginia does not require the landlord to send a notice warning the tenant of possible consequences, and the landlord can file for eviction immediately. The same applies to cases when the tenant breaches the lease in any other way. Once the magistrate or circuit court sets a hearing date, the landlord must notify the tenant in writing of the hearing.